into that database. You then have overlapping and the overlay of oversight from the Department of Justice, the IG's office, the FISA court that renews 215 every 90 days, and then finally the oversight from Congress. So each of the three branches of government have a role in assuring that privacy interests are protected here. And at the other end, you have the possibility, the strong possibility and the actuality that in some cases this has been instrumental in contributing to the prevention of terrorist attacks.
Thank you very much. Another issue we've talked about before is the problem of synthetic drugs. We've had deaths in Minnesota, as they have had in many other states, huge increase in the number of calls to the poison control line and others. And as you know, we passed some legislation targeting certain of these synthetic drugs, but I believe there's still more work to be done, and I'm working on the so-called analog drug provision, where I think that we could do more with that. But could you update us on the general state of synthetic drug use in the U.S. and how the provisions we passed last year are helpful, and what more you think we could do?
Well, I am somewhat familiar with that. No, it's on the increase. I am not familiar with the last part of your question as to what more we could do. It's really not our bailiwick. More DEA, and particularly in the time of budget constraints where we have to prioritize, that unfortunately drops down further on our list.
Right, and
we're sympathetic, supportive, but
right. We've been working with DEA on this issue. It's just that I continue to see that hasn't gone away, and it obviously contributes to other crime as well. So I just want to put it on your radar screen. We're working on a bill on metal theft. We've seen a lot of that throughout the country with buildings and issues. And I know you talked about high-tech stalking, so the cybercrime issue. You've said you believe the FBI must change with evolving technology to better address criminal and national security threats. What is the FBI currently doing to keep up with the changes in technology?
Well, internally, let me just say, we understand that we have to have the basic knowledge of technology to conduct investigations in this age, every agent. To the extent that you need to be refreshed on where we are in order to do our job is getting greater training. Our specialists, we've got more than 1,000 personnel around the country that are specialists in this particular area. But what I think the key for us is the NCI JTF, National Cyber Investigative Joint Task Force. Following the pattern of what we did after September 11th is understanding that we can't do it alone, having a task force concept where you have all of the major players in cyber arena participating so that if there is a substantial intrusion, we immediately have those who would be involved, whether it be DHS, NSA, DOD. There, trying to determine what how to address it is critically important. The other thing that we have done and put a great deal of focus on the last 6-8 months is work with private industry, providing information to private industry based on what we have found so that they can protect their networks. So growing internally, growing the NCI JTF, and then building our capacity with the private sector have been the three areas that we've been focused on.
Okay. Thank you very much, and thank you again for your service.
Thank you, ma'am.
Thank you, Senator Klobuchar. Senator Cruz.
Thank you, Madam Chairman. Director Mueller, it's good to see you.
Sir.
Welcome. Thank you for testifying. You and I have known each other a long time. A dozen years ago, you were my boss of the Department of Justice. Although let me say, any mistakes I may make, you will be fully held harmless.
You were clean, not to worry.
Well, and let me also echo the comments of colleagues of mine on both sides of the aisle, thanking you for your service and your integrity. You have spent many decades in public service focused on law enforcement. And indeed, I recall when we were working together at the Department of Justice, almost every day in the morning staff meeting, the question you would ask was essentially, are we locking up bad guys? And I appreciate that focus to protecting the innocent and to going after bad guys. And thank you for a lifetime of service.
Thank you, sir.
I want to talk about two topics that are both of significant importance. The first is the IRS, and I want to echo some of the concerns that Senator Sessions raised about the groups that we know or were targeted by the IRS that are reporting that they have yet to be contacted or interviewed by the FBI. As you know well, in any investigation that is in a highly politicized climate that involves potentially corruption and political interference from the White House, the investigation is a perilous endeavor and an endeavor of significant importance to the populace. And so I want to ask, what level of priority would you characterize the IRS investigation at the FBI?
I would say it's a high priority investigation in that it needs to be handled with care, but it also needs to be pushed aggressively because it's a very important case. As I think you're aware, we've worked together. I will pull no punches in terms of where that investigation would lead. And we would go down any path that would lead to evidence on individuals, organizations, or otherwise, and we're in the process of doing that. We have substantial, I think, numbers in terms of those who are working day in and day out on the investigation, both internally in the FBI, but also with support from the Department of Justice where we need legal process. Again, I'll have to get back to you in terms, and as I said to Senator Sessions, in terms of the pace and progress of the interviews, but I am aware of some of the ongoings in the investigation, and I do believe that we have moved it expeditiously during the period of time we've had it open, which is probably about a month now.
How many agents or other personnel have been assigned?
We have approximately 12 agents here in D.C. that are working on it, but also agents designated around the country because of the breadth of the investigation, who also will be working on it, depending on where the investigation takes us around the country.
And I wanted to ask additionally if the scope of the investigation includes looking into whether individuals have been politically targeted. I can tell you that we are hearing more and more anecdotal reports, not just of Tea Party groups or conservative groups that were delayed or targeted in C4 applications, but donors who supported Governor Romney in the campaign, who supported Republicans, who found within weeks or months of their support becoming public, suddenly they were targeted for audits. Now, those are very difficult questions to answer if there's a pattern of doing so, because those audits are not generally public. But do you know if the scope has included whether there was targeting of individuals for political activity by the IRS?
Well, I think you can understand that because it is an ongoing investigation, I'm leery about delving into much more about what is happening in the course of the investigation. All I can do is I assure you, and you know me, we'll push it wherever it goes.
Well, I would certainly urge the FBI not to narrowly circumscribe the scope, because the last time there was an instance of an administration trying to use the IRS to target political enemies, it was the Nixon administration, and it led to grave consequences. And I think the FBI is well situated to pursue a serious, impartial, fair, and yet vigorous investigation of whatever the scope of conduct and illegal conduct may have been.
Okay.
I want to talk about a second topic briefly, which is that I am concerned that this administration's priorities in the war on terror have been misallocated. That on the one hand, the administration has been less than vigorous in protecting the civil liberties and constitutional rights of law-abiding citizens. And yet, on the other hand, the administration has been less than effective in investigating and going after real-life terrorists. And a concern in particular I have is that your efforts and those of the FBI have been unduly constrained and handcuffed. And I would point to two instances. One, the Fort Hood shooting, where we had with Major Hassan considerable evidence, including his emails with Anwar al-Awlaki, talking about killing other service members. The FBI was aware of that, and yet we failed to stop that terrorist attack. Likewise, with the Boston bombing, we had considerable evidence with the Zarnaf brothers of their affiliation with radical Islamic views, their advocacy of those views. We had reports from Russia, and yet we failed to stop that attack. In your views, why is it that law enforcement was not able to connect the dots with Fort Hood and with Boston and prevent those attacks beforehand? And what policies have changed under the Obama administration concerning the investigation of radical Islamic terrorism?
Well, in neither case, whether it be Fort Hood or in the Boston case, would I say that there were policies that inhibited us from doing our job. I will tell you, in the Fort Hood case, prior to the time of Fort Hood, al-Awlaki was seen as a proselytizer, a radical imam, but was not known to have engaged in operational activities. Consequently, when we looked at emails, we did not look at them through the operational prism. Had we done so, perhaps other steps would have been taken. There were judgment calls that were made in the course of that as to, for instance, whether you interview Hassan, that in retrospect could have gone the other way. But I do not think that there were any constraints, statutory or otherwise, that enabled us or disabled us from doing the job. In the case of Boston, yes, we were alerted by the Russians to Tamerlan's movement towards radicalization, with the expectation from the Russians was that he was being radicalized and would be going back to Russia and to fight with perhaps the Chechens. They alerted to us. They alerted us. They wanted us to do whatever investigation we could and alert Tamerlan when databases. Went to the university or the college that he attended for a period of time, interviewed his parents, interviewed him, did, I think, a very rational, responsible, and thorough investigation given the information we had. He then goes back to Russia, and when he comes back, what we did not do, which we are going to do in the future, and that is the text alerts that come into the task force have to be identified to a particular person as opposed to just coming into a task force. In any event, there is nothing that constrained our investigation at the outset back in 2011. And in my mind, even if we had done the one or two things that in retrospect we could have done better, I do not think we would have been able to stop that particular attack. But I do not believe we were in any way constrained from doing the investigation that we thought necessary once we had the information.
Thank you.
Senator Franken, your timing is perfect. You are next in order.
Thank you. I apologize for, I was at a HELP committee hearing, and I'm sorry I've missed. Oh, and I hope I don't ask things that have been asked before, but my staff tells me that my questions are still relevant. First of all, I just want to thank you for your service, Mr. Director, and I believe our country is a safer place because of your steady leadership, and you will be missed. I'd like to turn to the subject of the surveillance programs that my other colleagues have been discussing. Mr. Director, I believe the government must give proper weight to both keeping Americans safe from terrorists and protecting Americans' privacy, and part of that weighting that properly is making sure that there's enough transparency, I believe, so that Americans understand the protections that are in place. Based on the briefings I've received, I I believe these programs include reasonable safeguards, and I believe the government needs to be more transparent with the American people about these programs, and I think the American people have the right to know what's going on, and to the extent that's consistent with national security. And I believe that the government can and should provide that information, again, in a way that doesn't compromise our security. Director Mueller, do you think that the government could be more transparent to the American public about these surveillance programs in a way that is consistent with national security?
Well, there are two levels of transparency. The first is transparency throughout the government, transparency to certainly the FISA court, it's under the FISA court, and also transparency to Congress. And given the briefings and the like, I think there was transparency to those elements. Now, when you talk about transparency to the American public, there is, you're going to give up something. You are going to be giving signals to our adversaries as to what our capabilities are. And the more specific you get about the program, the more specific you get about the oversight, the more specific you get about the capabilities and the successes, to that extent, you are have people sitting around saying, okay, now I understand what can be done with our numbers in Yemen and in the United States, and consequently, I'm going to find another way to communicate, and I'm going to keep that in my mind. And so there is a price to be paid for that transparency. Now, where that line is drawn in terms of identifying what our capabilities are is out of our hands. You tell us to do it one way, we'll do it that way. But there's a price to be paid for that transparency.
And that is the question. And in order to do these programs, you need the trust of the people. And of course, this all changes when there is a disclosure like there has been. And that's why we've obviously seen NSA and be more forthcoming with that kind of transparency that I've been asking for. I want to ask you specifically about Section 215, the authority in the Patriot Act that authorized the collection of telephone metadata. Importantly, by statute, only the FBI has the authority to request business records under Section 215. It's not the Director of National Intelligence, it's not the Attorney General, it's the Director of the FBI. Last week, Director Clapper declassified the fact that the telephone metadata collected can be queried only when, quote, there is a reasonable suspicion based on specific facts that the particular basis for the query is associated with a foreign terrorist organization. He also declassified the fact that in 2012, this database was searched only 300 times. Mr. Director, this is the kind of information that I think the American public benefits from knowing, and that can build further trust between the public and the government. Do you think that kind of information would be compromising before the disclosure?
I certainly think it would be educating our adversaries of what our capabilities are.
Okay.
And the specificity that the dialogue, and you have to with the leak, because the leak looks at just a small sliver of information on a particular program. The leak does not talk about all of the oversight. The leak does not talk about all the legal constraints in terms of how the program operates. One has to respond. So there has to be responsive transparency in this particular at this particular point in time. But generally, no. It educates the persons about our, as I say, about our capabilities, and makes it that much harder to prevent the next terrorist attack. And I will tell you that inevitably, the communications are the soft underbelly of the terrorists. They've got to communicate, and to the extent that we can't intercept those communications, to that extent, we can prevent terrorist attacks. If that goes dark on us, if we're black, then we're going to be sitting waiting for the next one without the tools we need to prevent that attack.
I understand your view on that. Let me ask a similar question. I've co-sponsored bipartisan legislation to release, again, consistent with national security, and this is I'm asking your judgment on this. The court opinions interpreting key provisions in the Patriot Act and the FISA Intelligence Surveillance Act. I think what's hard here is that it's hard for Americans to debate the merits of a law when the law is kind of secret. And do you believe that the American people would gain trust and benefit from perhaps a redacted version of these decisions and opinions by the FISA court on some of them?
Well, let me start by saying I understand the frustration. You're right. American people are frustrated. You may be frustrated not having access to the particular legal theories espoused in those opinions. I do know that the ODNI is looking at the possibility of releasing redacted copies. The lawyer for the ODNI spoke yesterday at the hearing and indicated that they're reviewing at least the key opinions with regard to 215 and 702 to see whether that can be accomplished. So I have to defer to the ODNI on that.
Okay, and again, and that's in the context of them already being disclosed. So,
well, the opinions, I don't think the opinion, maybe.
No, the opinions haven't been disclosed, but in the program's being disclosed.
Yes, yes,
yeah,
yes.
So, okay. Well, thank you again, and since this may be the last time you testify before us, again, want to thank you for your steadfast leadership.
Thank you. Thank you so much, sir.
And your service.
Thank you.
Thank you.
Senator Lee.
Thank you, Mr. Chairman, and thank you, Director Mueller, for joining us today and for your service to our country. With respect to Section 215 of the Patriot Act, is it the Bureau's practice to request records or other tangible things related to Americans that themselves are not relevant to an investigation, to obtain foreign intelligence information or to protect against international terrorism or clandestine intelligence activities?
I'm not certain I understand the question. Are you talking
so when you
about
make a request,
215? I mean,
yeah.
we're the applicants on 215 orders. But,
I understand. You're the applicants, and when you make the application, is it your practice to request things that themselves aren't relevant to the investigation? In other words, do you confine your requests to those things that are related to an investigation, or are they broader than that?
Well, in the 215 context, the application to the court and the court's finding defines relevance in that particular context. And as we've talked about and have been discussed the last 2 weeks. And so I would have to direct you to the orders and I know that they're not published, but the fact that the FISA court has ruled that the gathering of the metadata satisfies the relevance definition within the FISA statute.
Right, right. And so under that, with that understanding, that you necessarily do cover a lot of data that is itself not closely tied to an investigation, you can understand why a lot of people would be concerned and why they'd also have additional concerns about the fact that we've got not only secret data gathering activities going on, but also that they're undertaken pursuant to secret law, secret orders that the American people can't have access to. But if as we've been told, it's necessary for the government to collect and store really vast quantities of information, including information on Americans that is itself unrelated to foreign intelligence or terrorism investigations, then,
if I may, are you talking about the metadata?
Yes.
The telephone numbers, but I want to make certain we're talking about that, not content.
Yes, for now we're talking about the metadata. Then a lot of people have concerns about what, if any, limiting principles there are that would prevent the government from ultimately storing all information about all Americans, meaning just collecting more and more of this metadata and holding it for very long periods of time or perhaps at some point in perpetuity. Does the Department of Justice or does the FBI have a view on the constitutionality of gathering information on Americans and storing it so long as it doesn't perform queries on that information?
I think I understand the broader question. I would say that the Justice Department believes that the program in place, 215 program that has been upheld by the FISA court, is certainly constitutional. I would limit it to that set of facts because they're a discrete set of facts that with the attendant protections on privacy that I think the Department of Justice as well as the FISA court believe absolutely it's constitutional.
And at some point, do you sympathize with those who would say, even if this is metadata, the fact that you can collect that quantity of metadata, store it for a long period of time, and the fact that it can later be searched brings about a certain intrusion on privacy, even if it's a privacy intrusion perhaps not cognizable in court?
Well, and as you well know better than most, in Smith versus Maryland, it's not protected by the Fourth Amendment. So yes, sir, without a question of doubt, privacy concerns, but I would say they're de minimis privacy concerns compared to just about every other intrusion as you get more predication in an investigation. In fact, it's at the bottom level. Yes, do I think that would be concerning to people to know that there's a database? Yeah, absolutely, which is why I do believe that it's important that this is upheld by not just the Department of Justice, not necessarily just by the Inspectors General, but also by the FISA Court and Congress.
Okay. And, you know, I think it's important to remember also that the precedent you cited is, of course, decades old, and it didn't deal with the sheer volume of metadata that we're now talking about. The technologies that are at issue now didn't exist then, certainly weren't even contemplated then. And the more you aggregate large quantities of metadata, potentially on every single American citizen, and you give someone within the executive branch of government the power to search all of that, you do give them a pretty broad view into the lives of the American people. The more data you get, the more you add to that metadata, even if any one of those data points might be itself constitutionally insignificant. Don't you think you start to approximate a point at which you start to breach a reasonable expectation of privacy?
I certainly believe there quite probably is a scale, yes. But it was the same dialogue we had 20, 30 years ago about telephone toll records, which triggered the Smith versus Maryland case. And it is the same debate, albeit with metadata as opposed to telephone toll records, but you have pretty much the same piece of data in both cases. So I would argue that Smith, even though it's not exactly the same as a telephone toll record, the proposition that was espoused by the Supreme Court and Smith versus Maryland is applicable today.
Did we have the capacity?
To comparable data, let me just put it that way.
Right. Did we have the capacity to gather, analyze, and store in perpetuity that kind of metadata on every single American citizen at that point?
It would have been tremendously burdensome to do so at that point. You could do it, but it would be wholly ineffective. One of the differences today compared to 20 years ago is it was in the telephone company's interest to maintain telephone toll data because their billing was based on telephone toll data. Today, that is no longer the case. In fact, the telephone companies see it as a burden, a storage burden, and consequently, that information that was there in the telephone companies 20 years ago may well not be there today, absent 215.
Okay. Thank you very much, Director Mueller. I see my time has expired. Thank you, and thank you, Mr. Chairman.
Senator Hirono.
Thank you, Mr. Chairman. I join my colleagues in thanking you, Director Miller, for your service, and I extend my aloha to you in your future endeavors. I appreciate the fact that this kind of data that's collected, particularly under Section 215, could be helpful in connecting the dots. And yes, it is hard to figure out which dot might be the critical dot that helps you to foil a plot. So I have a question about, to the best of your knowledge, what are the costs of collecting and storing data gathered under Sections 215 and 702? For both your agency as well as NSA?
I would think you have to turn to NSA to respond to that question. I'm not familiar with what it costs.
But what about to your department? the
We don't do
FBI?
the storage. NSA stores the 215 data.
What about the collecting part?
The collecting?
Yes. collecting of
It
the
goes
data.
directly to NSA. The order directs that the data go to NSA.
So while you're the applicant
Yes.
for the collection of this data, it's NSA that I should ask about what the
Yes.
costs attendant to the data collection. Do you know how long the data collected under 215 is kept?
5 years?
Just 5 years? Do you think it should be longer?
No.
Okay.
I also don't think it should be shorter, but
Now, part of your department's, FBI's purview is prosecutions in Indian country. And you talked about that briefly in your testimony. And the Department of Justice recently issued a report on investigations and prosecutions in Indian country during 2011 and 2012. And this is a report mandated by the Tribal Law and Order Act of 2010. And it seems that while there has been a noticeable increase in the number of violent crimes prosecuted, those new figures do not reflect that 1/3 of all reported Indian country crimes were closed administratively by the FBI before they ever reached the formal referral stage. Moreover, approximately 80% of those investigations that were administratively closed were violent crime related. Can you shed some light on the reasons why so many FBI Indian country investigations are closed before referral to DOJ, and specifically ways in which your department can better address and investigate violent crime in Indian country, which is still a very big problem?
well, I think we all understand it's still it is a very big problem. And I know the Department of Justice, in particular the Attorney General and the Deputy Attorney General, this is one of their substantial priorities, which is why you see an increase of prosecutions in Indian country. I will have to get back to you on the figures relating to administrative closures. I am not certain if there has been an uptick in the number of administrative closures, why that is there. It may be consistent with the fact that we've done additional prosecutions. And with additional prosecutions, there's additional scrutiny of the underlying case, which has resulted in administrative closures. But I'd be just speculating. I'd have to get back to you with after looking at the issue.
Yes, considering that this is a major issue in Indian country, and to realize that in this report, so many of these cases are closed, I'm curious to know why. So
Okay.
Could you provide that
Yes, ma'am.
information to our committee? Senator Feinstein had a concern about the use of drones, and particularly with regard to the use of drones by the private sector. Do we have any special or specific legislation governing the use of drones by the private sector?
I am not aware of any.
Do you think that we should be thinking about federal legislation to protect individuals' privacy with regard to the use of drones by the private sector?
Well, I think there are a number of issues relating to drones that are going to have to be debated in the future as they become more omnipresent. Not the least of which is the drones in airspace and the concerns you have on that, but also the threat on privacy. We already have, to a certain extent, a body of law that relates to aerial surveillance and privacy relating to helicopters and small aircraft and the like, which I think could well be adapted to the use of drones. But it's still in its nascent stages, the debate, and but it's worthy of debate and perhaps legislation down the road.
Especially as the hearing that we had in one of our committees, I think it was this one, where these drones can be very, very tiny, but store a lot of data, and there could be cameras on it. And I think this is a burgeoning concern for many of us. With regard to the data that's collected under Sections 215, in particular, the millions and millions of pieces of information collected, NSA indicated that there were 300 queries that were made with regard to this data, and they have to forward those queries to you, and 10 to 12 in cases were referred to you.
Well, only, they will refer them to us when they have a U.S. number that comes out of their query.
I think as a layperson, yeah, I'm having some difficulty understanding what the process is, what NSA does with all this information, where you come in. There's some nexus between the NSA looking at this data, 300 queries, and then forwarding to you, say, 10 to 12 cases where they see some further investigation needs to occur. So what happens to all these other cases, that other numbers that were queried by NSA?
Well, when you talk about 10 or 12 cases, these are cases where the identification of a number led to a terrorist case or corroborated other information we had in a terrorist case. But if you have NSA on a number in Yemen, for instance, and they want to know who from the United States is in contact with that number, you've got that number in Yemen, they take that number of Yemen, and they run it against the database of numbers to see whether there's any number in the United States that is contacting that number in Yemen. And when that number comes out, we mentioned a couple of examples here in, say, San Diego, they will refer to us and say that there is a number in San Diego that is in contact with this number in Yemen, which is terrorist-related. We then go get a national security letter or other paper to determine who has that number, who is the subscriber to that number. And once we get the subscriber to that number, then we'll build the investigation. That's, in simplified form, what the process is about. But absent that capability, we would never identify that person in San Diego who is in contact with the terrorist group in Yemen. And that is what we did not pick up in 2001. Where the intelligence community was on a number in Yemen, and this individual, Al-Midhar, ended up being in the United States. And had we had that program in place, we might well have picked up Al-Midhar.
So in your view, in spite of the fact that there are literally billions of pieces of information collected, and in your view, the dot connecting possibilities justify this kind of breadth of data collection?
Given all the precautions, given all of the constraints on the program, given the oversight of the program, yes. But it's the program as a whole, not just the fact of the accumulation of the records, but how it is handled and what kind of information is it comes from it. I was asked earlier today, why did we miss Boston? Why did we miss Fort Hood? There can be one piece of information that comes out of it that would prevent the attack. People will say that we were not sufficiently attentive to Al-Awlaki's email traffic. Had we been, we would have stopped Fort Hood. So to the extent that this provides dots for us to connect, it's very useful. Yes. You never know which dot is going to be the one that breaks the case, and to the extent that you remove the dots from the playing field, we just don't have those dots to connect.
I certainly understand that. Thank you, Mr. Chairman.
Senator Flake.
Thank you, and I want to echo the sentiments of my colleagues in thanking you for your long and dedicated service. I was fortunate to be on the Judiciary Committee in the House, and we had interactions there, and I've enjoyed the association we've had and your candor always here, and I appreciate that. I feel kind of like, well, I grew up with 10 brothers and sisters, and when the dessert plate is passed around and you're the last one, and all the dessert is gone, and in this case all the questions have been asked and to your credit answered. I had some questions with regard to the information being held and how long, but you pretty much answered those. But there was one thing that I still wanted to ask with regard to, I mean, this 215 has been around, what, since 01 in some fashion?
Probably 0102, but in this fashion since I think 2007.
Okay. How has the legal interpretation, internal interpretation, you rely on your own memos that you produce to interpret 215 and what you're able to ask and what kind of standard is applied, has that changed over time since 07 or perhaps before?
Well, prior to, and I'm not certain what year happened, but it was placed within the FISA court, I think, beginning in '07. And while, yes, the Justice Department has made application and to the FISA court has interpreted 215 to allow this program. So it's not just the Justice Department opining on what it thinks 215 means. It's the FISA court that has issued opinion saying this is the appropriate interpretation of 215.
All right. One question on the holding of data. You hold it for 5 years, you say, and if it has not been queried or minimized during that period, then you get rid of it.
Yes.
But that
NSA, yeah, NSA holds it.
NSA, yes. But that which has been queried and then duly minimized where appropriate, I assume that can be queried again and again. And during that 5-year period, you say, like last year, it was queried 300 times. It's the same information, basically, or the same database, the same metadata that is queried again and again.
But the database is refreshed each day, so that which is 5 years old is dismissed from the database, and the database picks up new numbers.
All right. So it's just a rolling 5-year period. Yes. Anything older than 5 years is just...
which enables us to go back. You may have a number called in for instance, the Al-Midhar out of San Diego made the call to the Yemen telephone number back in, I think, earlier in 2000. And so you needed that number in that database from a year before in order to tie in that particular number to the terrorist number in Yemen. And so it gives us that database for a period of time which has the relevant information in it. If you go to one of the providers, they may keep it for 6 months, may keep the data for 12 months, 16 months, or 18 months, something along those lines. And so you would not be able to get the same data from the telephone carriers because they have no data retention responsibilities as you would get when we have that 5-year database.
All right. Well, thank you. Just in conclusion, your service will end sometime September.
Yes.
What advice would you give to this body in terms of what changes are needed moving forward and how we handle situations like this? Obviously, this came as a shock to most of the country that this kind of data was being collected. In terms of, and you have concerns, and I share them, about too much information being out there. But what is the proper balance for this body to inform or to keep the citizens aware enough that their rights and their civil liberties are protected, but that we're also giving the appropriate federal agencies the tools that they need to thwart attacks? Is there any advice that you would give that you haven't given before?
No, I would. The only thing I would say is that there are levels of transparency in this particular case where it's not necessarily always the case. It was not only the Department of Justice, not only the Inspector Generals, and we've had Inspector General reports on these particular programs, but the FISA court and Congress, various committees in Congress. And to the extent that each of those entities are brought into the loop and know and understand or are able to question, to a certain extent, assuring that these entities have coverage, the American public has to put some faith in these institutions. You're always going to have those areas of classified areas where it doesn't make any difference whether it's a cyber arena or the military arena or the intelligence arena like this, that disclosing our secrets will make us that much more vulnerable. I mean, and there's always going to be a level of frustration. The only other thing I'd say is that there are going to be additional terrorist attacks. One of the most debilitating things for those of us in our positions is to try your darndest to prevent it, but there be an attack, and then you were immediately attacked for why don't you do more? And we always believe, regardless of the attack, that it's incumbent upon us and others to go back and do a scrub and see what we could have done better. But the tone of how you do that and the way that you do it would be helpful to those of us who worry about this day and night.
Thank you, and thank you for your service.
Senator Durbin.
Thank you very much, Mr. Chairman. Director Mueller, thank you so much for your service. I've enjoyed working with you over the years. I recall, in particular, when you arrived at the FBI after 9/11, and I took note of the fact that the computer system at the premier investigative agency for law enforcement in the United States of America on 9/11 was as archaic as anything anyone could imagine. The computer system you inherited at the FBI had no access to the internet, had no word search capability, and was unable to transmit materials and documents. The photographs of the suspected terrorists on 9/11 were sent to the FBI offices across America by overnight mail because they couldn't be sent by the computer system that you inherited. We had many conversations, some attempts, some missteps. Tell me today, where are we 12 years later in terms of the computer system of your agency?
One of the reasons for staying the last a couple of years is to get over the hump in terms of the computer systems. We have this computer system called Sentinel that has been operative for the last 2 years. It's cutting edge in terms of case management. Many of our other programs we have not only upgraded but are now incorporating in a much more effective network. But I will tell you, it was one of the most frustrating aspects of this job is trying to adapt new technology in an institution that has unique business practices and to try to modify those business practices at the same time and upgrade those business practices at the same time you're trying to adapt to new technology, particularly with the contracting mechanisms within the federal government, where if you have a 5-year contract, things are going to change, new technologies are going to come along, and the fact of the matter is there's very little room in those contracts for any ability to change, to adapt to the times. But if you had seen, I mean, I very vividly remember being in our intelligence, what we call SIOC, intelligence operations room, in September 11th, and the papers stacked up. And in Boston, we were back in the same place, and there's not a piece of paper to be seen. And also, to the credit of the Bureau, the ability to identify those two individuals in Boston within 48 hours after it occurred, utilizing the various technologies in our laboratory, as well as up there, is, I think, testament to the fact that we've come a long ways. Still ways to go, but we've come a long ways.
Well, let me just say, for the record, in addition to bringing integrity to the position which you have, in addition to helping keeping America safe with an extraordinary degree of success, I think your legacy is going to include this, that the information technology available in your department is now meeting 21st century standards, where when you inherited it, it was, as you say, a creation of, quote, unique business practices. I think you're being very kind in that characterization.
Can I just add one thing? We're okay today, but as you well know, technology costs money. And we sequestration, I'll put in another plug. This is an issue that all too often gets overlooked and perhaps cut, and it should not be, because you cannot run an institution like ours unless you stay current with the latest technology.
And sequestration is, the way it's been characterized, the way it's been implemented, is a pervasive problem. I met yesterday with Director Clapper, and he talked about the impact of sequestration on doing checks on employees for security clearances. We've had to reduce the number of checks of those current employees when it comes to security. And now we're dealing with one former contractual employee who has disclosed things which were very important to our national security. Speaking of that issue, on Section 215, which you've been queried about quite a bit, I've offered an amendment over the years to try to limit the metadata collection in terms of specific suspicion. That was the original standard. It eventually was changed with FISA Act reauthorization. But yesterday, the Department of Justice, I hope you're aware of, released publicly, according to reports we have, the standards for searching the database of phone records when there is, quote, reasonable suspicion based on specific and articulated facts that the information sought is, quote, associated with a specific foreign terrorist organization. The standard that they released yesterday, which they are now going to use, is actually stricter than the standard that I'd been proposing over the years for the limitations on 215. Can Section 215, do you believe, be revised to require connection to a suspected terrorist without affecting the ability to obtain useful information?
I'm a little bit confused because the, what do we call it, selector, the telephone number that is run against the database has to be identified as being, I don't want to say it, meet the reasonable suspicion standard with regard to terrorist attacks. That particular phone number. Yes. That's an appropriate standard for that particular phone number because you can't pick a phone number out of the blue or for some other thing. You have to have it tied into terrorism, and then it's pushed against the database. Now, I don't know whether your standard as you are supporting it is the standard you apply to collection of the records or the standard you apply to identifying the selector against the data, which you're going to use, which you're going to put against the database. If you see the distinction,
our standard is on the collection of the records.
See, I think that's a little bit different. The standard we're talking about here is the identification of the selector that you are going to run against that database of records.
So if the provider, if the telephone provider, for example, were to retain the records for 5 years, and you would have access through our government agencies and through our processes to access those records for government purposes if there is a suspicion, would that meet the needs of collecting the information to keep us safe?
I don't, and not in the same way the program does now for several reasons. First of all, you'd have to go to a number of telephone companies. You'd have to get legal process and go to a number of telephone companies. Then you have to hope that those telephone companies have some records retention capability. I can assure you it's not going to be 5 years.
Not today.
Not today.
It could be required of them, though.
It could be. It could be. I'm not saying it couldn't be done, but you're asking me if there's a distinction between the program run today and how you propose to perhaps amend it. And there's some downsides. You know, the balance is for Congress to decide, but there are downsides in terms of the time it would take to serve it, the time it would take for them to get it, and in every one of these cases, time is of the essence. You do not want to have to delay 6 months or a year to get the information to prevent the next terrorist attack.
We've been very patient with your time, and I thank you for your service, Director Mueller. Wish you the best.
Thank you.
So I'm your last director.
Happily so, happily so.
Good to see you. 3 topics I want to touch on. The first has to do with the investigation into the conduct of the IRS. The background to this is that the tax laws allow you to form up as a charity under Section 501c3, but if you want to lobby, you've got to form up under 501c4. And then, if you actually want to electioneer, you've got to form a so-called super PAC. The difference between a 501c4 and a super PAC, as you know, is that a super PAC is required to disclose its donors. So what developed was a pattern of folks filing as a 501c4, but then going out and electioneering as if they were a super PAC. And the problem with doing that is that there's a place on the form when you file for a 501c4 that requires you to assert and aver under oath that you will not seek to influence elections and so forth. So there appears to me, we had a hearing on this in the committee, to be almost a layup case for 18 U.S.C. 1001 false statement violations based on what appear on their surface. Again, this requires investigation before you can make any final determination, but it appears on the surface that these are flagrantly false statements made under oath to a government agency for the purpose of misrepresenting the intentions of those forming the 501c4. That never comes to the FBI because there's an agreement between the Department of Justice and the IRS that unless the IRS has put a case together and forwarded it, we're not going to look at it. And I think the 501c4 applicants were taking advantage of that, and the IRS was feeling a bit intimidated because there were some very powerful people in this country on both sides of the aisle behind the problem, behind the 501c4 problem. So I hope that as you're looking at the IRS question, part of what you're looking at is whether or not something that, as you and I both know, is really a plain vanilla prosecution, a false statement case, is something that the FBI should turn away from because the IRS has not yet referred it when it's kind of out in the plain light of day. And I hope that you will consider that question as the IRS investigation moves forward. It may not be the kind of question that leads to a charge. It may not be purely investigative, but I think it's an important policy question. And I think it's important for the American people to know that when people are doing something that appears on its face, again, subject to rigorous investigation and proof, but appears on its face to be a flagrant false statement, the answer from the government, yeah, but it wasn't referred to us in the right way, isn't a very convincing answer to what appears to be a fairly blatant criminal act. Not a very major one, but a very blatant one. So I'd like to ask your comment on that, if that's something that you will consider as part of your look at this.
Yeah, I'm not familiar with any such agreement. I'll have to look at that and discuss and see what this
We'll make that a
is.
question for the record, and you can get back
Happy.
to me later. The second is we met recently with some of your folks, some of the Department of Justice folks, and the Office of Management and Budget to try to figure out how our prosecutorial and investigative law enforcement resources should be structured to focus on the cyber problem. And in the time that I've been in the Senate, 6 years now, I've watched that administrative structure morph really almost every year to something new, something different. And I've been out to NCI JTF and some of your facilities, and I applaud and impressed by how hard the FBI works to keep track of who's coming in the doors and windows, attacking our country and our companies, and trying to get those alerts out as quickly as they can to the companies that are being attacked and having their intellectual property stolen. But it hasn't resulted in a lot of prosecutions. And as best I know, there is not a single case that has ever been prosecuted of a pure industrial espionage cybersecurity attack from outside the country on an American company. There's always been something involved, a CD that got stuck in somebody's pocket, but the pure hack, I'm not aware of a case that has been made yet, and that's a question I ask pretty frequently. I think this is a boom area. I'm delighted and pleased that the administration, in a time when most other parts of the government are being asked to cut, is actually investing more in cybersecurity at the FBI, at the Department of Justice, at the NSA, at the Department of Defense, and in other places, because it's a huge vulnerability, I believe. And I know you're on your way out, but I hope that one of your departing messages to the Bureau will be, we need to keep looking forward to see what our structure should be to take on this threat in the years ahead. I don't think we're there yet. I think we've made immense progress. I think we're in a state of constant flux as we try to adapt to the problem. But when you look at a problem that is described by very senior officials as us being on the losing end of the biggest transfer of wealth by illicit means in human history, basically because the Chinese are raiding our corporations and stealing our intellectual property in a nutshell. That's a pretty serious problem set, and it's only going to get worse because it has its transnational sabotage and its multinational criminal components as well. And I hope that you guys have an open mind and have somebody detailed to looking forward and saying, what does this look like down the road? How should this be structured so we're really after it? When we had the drug problem, we started a DEA to handle it. What is the structure that this should look like down the road? And I know it's such a mad scramble right now, and you're working so hard, and people are doing such a great job, it's hard to kind of pop your head up out of the day-to-day fight and plan ahead. But I think that would be a good legacy for you to leave, that was a look forward and let's see what this thing should be like 5, 10 years from now.
I venture to say anybody in the Bureau knows the focus has been over the last year on cyber in a variety of ways. And we have to put our own house in order first.
Yep.
And we are doing that. We're not there yet, but we have to adopt over the next several years an organization that lends itself to addressing itself with more specificity to particularized threats that have been prioritized, of which cyber will be a substantial one. We now have entities or counterintelligence and cyber because they're like that. And our organizational structure is morphed into a threat-based organizational structure as opposed to a qua-program organizational structure. And we've got to continue to do that. One of the focal points outside the FBI, though, is the NCI-JTF. My firm belief that for us to be successful, we have to have people at the table right at the outset and determine whether it's national security or criminal or what have you, but you need all of the facts, all of the information on the table, regardless of the classification side, because there may be something up there that will help you on a criminal matter down below. But have everybody in the relevant players in the government working at the NCI, JTF, or some comparable facility. And then lastly, with the private sector. Once we have our act together administratively, and have, my own belief is, generally co-location, with the exception of NSA because of what they've got, but the rest of us to be relatively co-located. Then, in my mind, you need the partnerships in the private sector to come together and equip themselves to share information, and then set up conduits between the private sector and the federal government that will assure privacy, but also enable us to share information in ways that we have not been able or had to in the past. And so I think we're moving towards that structure, but we have a way to go. And I can tell you, with my successor, it'll be we'll have some discussions on this.
Good. The last point, we've addressed it a little bit, but I'd like to make the point that I do think that we overclassify. It's much easier to classify than it is to declassify. There are a whole variety of reasons why, some good and some not so good, for classifying programs and classifying materials. But it seems to me that a lot of the stuff that has been said about the NSA programs and about the FBI's support of them could easily have been said beforehand without compromising those programs in any significant respect. Particularly the multiple checks and balances. The number of guards at the door to the vault before anybody can get any kind of information. Both houses of Congress being briefed in on programs like this. Inspectors general being independently accountable to review programs like these. The internal oversight of the executive branch apart from the independent inspectors general, and the rigor and frequency of the audit that is done for those programs. The fact that regular line United States District Court judges are brought in on detail to serve on the FISA court, and they have to, in various ways, sign off on these programs. You have as strong an array of protections under our system of separated government as one could possibly create, I believe. I don't know that a single stone has been left unturned in terms of putting eyeballs onto making sure that these programs were carefully used and never abused. So that kind of story, I think, is one that doesn't hurt us to get out first. Before this incident, people knew that there were ways in which we were protecting ourselves, and we could have said generally that, without getting into the details of any of these programs, when we look into programs that affected Americans' privacy, we go all in on making sure that there aren't shortcuts and making sure that only qualified people get it. And so I think the lesson from this going forward is that as much as there's a public interest in classification of a lot of this information, there's also a public interest in declassifying it. And in some cases, I would contend that declassification has exactly zero national security risk associated with it. It just kind of got swept up with a bunch of other stuff because the program is classified. And we depend on you to do this because senators aren't declassifiers. The only way that the Senate Intelligence Committee can declassify anything is so complicated that it's never been used in the history of the Senate Intelligence Committee. So I'd urge you to, I'm speaking through you now, I think, to a whole lot of other people as well, but I do think that a more persistent focus on what could be declassified and what would help for these foreseeable events of disclosure would be a good policy to pursue. Your thoughts? I
understand your sentiments. I do believe there's a price to be paid. We tend to think that people know and understand the internet around the world. But you have persons who want to undertake terrorist attacks that don't have a full understanding of the internet. And to the extent that you expose programs like this, we are educating them. We're educating them about how the internet works actually worldwide. We are educating them as to what our capabilities are, and the brighter and the smarter of them will be educated and find other ways to communicate. And we will not pick up communication we want. Now, that's not to say that the scale shouldn't be on the other side. It is much easier to explain to the public when you don't have the restrictions, quite obviously, of classification. All I'm saying is I do think there's a price to be paid. Not always. There are occasions where we can declassify things, but I wouldn't I would not underestimate the price to be paid by a substantial, let me just put a substantial disclosures.
Yes, I agree. I think we have to be very sensitive to that, and we have to be particularly sensitive to that when we're talking about the operating mechanics of a particular program. But when we're telling the American people, we're not going to raise the question of what we're doing, but we want you to know that when, as and if we do anything, here are the kind of procedures we use. You would never tell anybody about an ongoing investigation, but we tell everybody about the warrant requirement, about minimization, about the things that protect American security. And that process is also classified when it comes to these NSA programs.
Good point.
That's where I think we can make some ground.
Yep.
This is, I think, the end of your last appearance before this committee, so let me thank you very much. You have been a terrific director of the Federal Bureau of Investigation. Before that, you were a terrific member of the Department of Justice and a terrific United States attorney. You have made an awful lot of people proud, sir, and we are very glad to have had the chance to work with you.
Well, thank you for that, but it's men and women of the FBI that make the place run, as you and I both know, having been in comparable positions. But thank you.
Well said. Thank you.